What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hello, everybody. Welcome to the new short podcast series sponsored by the Economics Committee, where we hope to give you the highlights of our latest programming.
Your hosts today are Nathan Blalock.
And I am Gabriela Antonie, and joining us today is Josh Hazan. So, Josh, we're thrilled to have Josh today. He is an antitrust associate at Simpson Thacher in New York City. He represents companies in obtaining antitrust approvals from the DOJ, FTC, and international competition authorities in connection with mergers and acquisitions. He also defends companies in civil antitrust litigation related to alleged price fixing and other antitrust issues. So, Josh, thank you so much for being here with us today.
Thank you for having me.
So, Josh, in October, you reported on a panel hosted by the ABA Antitrust Law Section about acquisitions of potential competitors. And it featured Commissioner Noah Phillips of the Federal Trade Commission, Koren Wong-Ervin of the law firm Axon, Veltrup & Harkrider, and Diana Moss, the president of the American Antitrust Institute.
That's right.
Well, today we'd like to have you return to that topic. Some recent events have brought this issue to the forefront of many antitrust discussions. And so we'd like to recap some of that program and the developments that have happened since.
But actually, before we dive into the details with the highlights of the program, it might help our audience to fix concepts and maybe define for us what we mean by acquisition of a potential competitor.
Sure. So potential competition can constrain an incumbent in a couple of ways. The first way is through what's called perceived potential competition, which means that the incumbent's decisions today are constrained by the possibility that the competitive landscape will be different tomorrow. So if I'm a dominant incumbent who sells widgets for $1, I might be able to raise the price to $2 for some time, but I know that if there's a potential entrant waiting in the wings, then the higher prices could encourage new entry and would make the market more competitive in the long run, which I surely wouldn't want. So I'm constrained in what I can charge, and acquiring that potential entrant would remove that constraint. The second type of competitive constraint is known by economists as actual potential competition. Now, that refers to the competitive constraints that are expected to rise in the future. So if I develop and patent a new vaccine for a disease, and I'm the only one who can make that vaccine, then I'm a monopolist. But if I know that there's another company developing an alternative vaccine to defend against the same disease, and my monopoly won't last if that company makes it to market, then I might want to acquire that potential competitor in order to protect my future monopoly as well.
I see. So perceived potential competition is like the threat of competition should there arise the incentive to enter. But actual potential competition is more like impending competition because the incentive to enter already exists.
That's right. And an acquisition of a company may involve the loss of either perceived or actual potential competition, or even both. Antitrust law aims to prevent the loss of either kind.
That's interesting. I'm curious, which type of potential competition did the panel cover?
So the focus of this panel was on acquisitions that result in the loss of actual potential competition.
Well, why should we care? What are the potentially detrimental effects of loss of actual potential competition?
Well, in theory, the effects of lost potential competition can mirror the effects of lost current competition. So higher prices, lower quality, worse service, less innovation, and less customer-friendly policies than we'd otherwise expect in a competitive market, except the effects would be felt sometime in the future.
So, Josh, what did our panelists describe to be the challenges to identify anti-competitive acquisitions of potential competitors?
So that distinction between current and future harm is what makes potential competition so difficult to evaluate and so difficult to act on as an independent theory of harm in antitrust cases. Mostly everybody agrees that, at least in theory, anti-competitive effects are possible when an incumbent neutralizes a competitive threat by integrating it or killing it off, a so-called killer acquisition. But there's widespread disagreement among practitioners and policymakers and academics about whether there's actually evidence of these anti-competitive effects in real life.
So what's the source of the disagreement?
Well, unlike an acquisition of a current competitor, there's just no track record of competition between the acquirer and the target. So the whole inquiry is really counterfactual. How likely is it that the potential competitor would have made it to market? When would that have happened? How effective would the entrant have been once it got there? These are tough questions to answer even in retrospect, and they're even more challenging when we're looking ahead. So it turns out that predicting the future is pretty hard, even for lawyers and economists.
I see. So it's almost like the antitrust version of if a tree falls in a forest and no one is around to hear it, does it make a sound? Intuitively, you think any business might succeed or fail at that stage. So to evaluate whether consumers would be better off when the acquired firm has not made it, where it actually has an impact, that's a difficult question to answer. What were the panelists' views about that?
Well, Dr. Moss was the most convinced that anti-competitive mergers are being missed. On a macro level, she thought the problem was most pronounced in the high-tech sector, and she highlighted the tech companies' shopping sprees over the past couple decades, including more than 700 by Google, Microsoft, Amazon, Apple, and Facebook alone, and almost none of those were challenged. She also noted some research that suggests that increased acquisition activity has correlated with reduced innovation and entrepreneurship, namely after acquisitions in a market, venture capital investment in that market decreases. Ms. Wong-Ervin, on the other hand, she believes that there really isn't any evidence that consumers have been harmed by the various tech acquisitions over the years. She thinks the possibility of being acquired is actually what incentivizes many startups to invest and innovate in the first place. And that actually leaves consumers far better off. So she also noted that to the extent that venture capital investment declines after an acquisition, that might simply reflect the fact that investors expect the money's already been made. In other words, if Google buys a travel search site and VC funding for travel search sites slows down after that, it probably just means investors think it's unlikely Google will have a need for 2 travel search sites. So there are fewer exit options for their investments.
Well, how about Commissioner Phillips? I'm sure people were curious to get his take.
Yeah, Commissioner Phillips fell somewhere between the other two. He acknowledged that there may be room for agencies to be more aggressive in certain cases, but he emphasized that agencies already actively seek to address nascent and potential competition concerns when they come up. And he wasn't convinced that there's a widespread under-enforcement problem, either in the tech sector or anywhere else. Still, he expressed an openness to revisiting his stance if more evidence comes to light. And he noted that the FTC is currently in the middle of an extensive study on the effects of M&A activity in the high-tech sector.
So, Josh, in some sense, it seems like this issue is actually not new at all. For example, there have been court cases as far back as the 70s that talk about potential competition issues. So how come we have such a hype right now?
Well, there's been some debate for a long time among academics and policymakers about what the antitrust law should have to say about the growth of the largest tech companies. And last fall, that debate kind of came to a head when the staff of the House Judiciary Committee reported the findings of a big year-long investigation into competition in digital markets. The report looked at online search, online commerce, social media, mobile software, and some other areas. And it basically called for a wholesale reimagining of the antitrust laws. Now, the report's specific findings and recommendations were pretty controversial, and they go well beyond the scope of the October panel. But one finding that was pretty important was that the largest tech companies have become dominant in part by buying up the nascent competitors who might conceivably challenge them, and that the existing legal standards make it too difficult for enforcers to effectively prevent that type of anti-competitive merger.
But antitrust agencies in the U.S. have brought enforcement actions in the past based on potential competition theories. Isn't that right?
That's right. Commissioner Phillips walked through some of those examples during the panel. For instance, in 2019, a company called Illumina was dominant in DNA sequencing technology, and it tried to acquire a small new entrant called PacBio, which had made some technological advancements that improved accuracy and throughput. The FTC alleged that the acquisition would eliminate a nascent competitor that threatened Illumina's monopoly power, and the parties ultimately abandoned that merger. And then last year, the DOJ tried a case against the airline booking service provider Sabre over its proposed merger with Farelogix. Now, Sabre sold the dominant system for connecting travel agencies and travel suppliers, like airlines, and Farelogix had developed software that allowed airlines to sell packages directly to travel agents. The DOJ argued that Sabre's goal was to prevent Farelogix from disintermediating its own system, but the court found that there wasn't enough evidence that the parties actually competed, so it denied the DOJ's injunction.
I see. So it sounds like agencies have had some mixed success when litigating this issue.
It's true, but despite the mixed success, Commissioner Phillips said during the panel, he thinks both cases were good ones. That's not really a controversial viewpoint, though. The main debate today is about all the cases that have not been brought. In other words, does the relative infrequency of potential competition cases indicate that there's systemic underenforcement in that area? And if so, what should we do about it?
Interesting. And going back to the House committee report, did it have anything to say on these points?
Yeah, some of the proposed reforms in the House report include changing the legal standards to put the burden on companies to show a merger is not anti-competitive, instead of today where the government has to show that it is anti-competitive. It proposed changing the notification thresholds for companies deemed to be dominant so that all acquisitions are subject to review for them, as opposed to today where only acquisitions over a certain size have to be reported. And it also proposed increasing funding for the antitrust agencies that enforce the laws.
All these sound like big departures from the current thinking. Do we really expect any of it to be implemented anytime soon?
It's hard to say. The report just reflects the opinion of the staff of one party, of one committee, of one half of one branch of government. So it so far hasn't resulted in any tangible policy changes, but it could be an indication of which way the wind's blowing. In fact, in the first week of February, Senators Amy Klobuchar, Richard Blumenthal, and Cory Booker introduced a bill in the Senate that would implement some of those policies.
So did our panelists believe that existing antitrust laws are capable of protecting against lost potential competition, or did they think that policy changes were necessary?
Well, maybe not surprisingly, whether the panelists believed that policy reforms were needed corresponded to whether they believed there was an underenforcement problem in the first place. So Dr. Moss, for example, she thinks that the agencies are currently capable of making up some of the perceived deficit in enforcement using tools that they already have in their toolbox. So, for example, she suggests that the agency should shift the evidentiary focus of their merger reviews to the merger party's subjective intent, like whether their documents suggest that the goal of an acquisition is to add new capabilities or to neutralize a threat that's out there. And that they should also look at the company's track records, like whether they've done a good job integrating their acquisition targets in the past or whether they've let them wither and die, which could suggest that they had an anti-competitive intent in acquiring them in the first place. Dr. Moss also wants to explore some other policy changes, though, like new structural presumptions that would make it harder for companies with high market shares to make acquisitions, even in adjacent markets.
That sounds very similar to the House Committee Judiciary report.
That's about right. And it's important, though, that not everybody agreed with her. Ms. Wong-Ervin's starting point was that there isn't any reason to believe we have an underenforcement problem. So it makes sense that she also doesn't see any reason for the agencies or policymakers to do any heavy tinkering. She also doesn't favor emphasizing the kinds of evidence that Dr. Moss suggests, in her view, a track record of killing acquisition targets might simply reflect the fact that the targets frequently just don't succeed, especially in the often speculative world of Silicon Valley. And Commissioner Phillips again landed in the middle of the two. He thinks that evidence of anti-competitive intent can be useful, as can a company's track record. For example, in Silicon Valley, it's common to do, quote, acqui-hires, where a buyer acquires a startup mostly for the talent of its key personnel. And if those key personnel tend to depart the acquiring company within a short period, it might suggest that the acquirer's goal was to neutralize a competitive threat instead of to onboard the new talent. But Commissioner Phillips was also pretty averse to some of the more drastic proposals floating around, like merger bans for large companies or structural presumptions that would affect tech companies. Here's how he put it. Quote, the ecosystem of buying small techs and pharmaceuticals and others and all the innovation that ecosystem supports is really very important to our economy and to America's comparative advantage. These are net goods. We like Silicon Valley, and it's not an area where we want to get it wrong. So we need to recognize the risk and perhaps consider adjusting the error cost framework, but we need to be careful, end quote. One of the policy proposals in the House report caught his eye, though. He really does like the idea of increasing the budgets for the DOJ and for his agency, the FTC.
I guess that's not a surprise, but good to hear. There have been some major development in this area since the panel was originally held. Can you tell us about them?
That's right. There really have been. The first is that in November, the DOJ challenged Visa's proposed acquisition of Plaid, which is a fintech firm that's developing a payments platform that DOJ said could be used to challenge Visa's position in online debit transactions. The DOJ's complaint focused on Visa's internal documents and the high purchase price, which was nearly 50 times Plaid's earnings, to support its theory that Visa was trying to eliminate a nascent competitive threat. And we don't know how that case would have been decided, though. The trial was scheduled for this past June, but the parties abandoned the deal in early January. The second and maybe more significant development happened in December when the FTC and 48 state attorneys general sued Facebook to unwind its 2012 acquisition of Instagram and its 2014 acquisition of WhatsApp. Instagram, according to the FTC, had become an existential threat in social networking because it had better functionality on smartphones at a time when social networking was shifting to mobile. Similarly, the FTC alleged that WhatsApp's position in mobile messaging could be used as a springboard to launch a social networking competitor. The FTC and the state AGs claim that the acquisitions were actually intended to neutralize the applications as serious competitive threats. Now, in late June, the judge dismissed the FTC's complaint on the ground that it had failed to adequately plead the first element of a monopolization claim, namely that Facebook is a monopolist in the market for personal social networking services, or even that it had pled what the precise contours of that alleged market are or who else competes in it. The judge dismissed the case without prejudice, though, which means the FTC has an opportunity to amend its complaint, so it's hard to predict how this case is going to come out in the end. On one hand, if the FTC is able to fix the deficiencies in its complaint, it'll be armed with some less than ideal sounding language from internal communications by Facebook's executives, like, quote, suggesting it's better to buy than to compete. But there are still a number of hurdles that the government will have to overcome if it makes it to trial. For one thing, the government has to show that consumers would have been better off without the mergers. But Facebook has continued to develop and invest in both platforms, and really today both are more advanced and vibrant than ever. So the counterfactual, showing that they would have been even better, is going to be pretty hard to prove. For another thing, courts consider a forced divestiture to be a pretty severe remedy. And maybe for that reason, it hasn't really been imposed in a long time. And the amount of time that's passed since the acquisitions and the extensive integration that's occurred, it might just mean Facebook can't easily unscramble the egg to make a divestiture workable. And another thing that the government will need to explain is why it did not try to block the deals when it reviewed them at the time. Although there's technically no statute of limitations on a merger challenge, A judge might not be inclined to give the government a do-over if it means upsetting the company's long-settled expectations. As Facebook's general counsel explained, a win by the government could send, quote, a chilling warning to American business that no sale is ever final, end quote. In fact, the judge dismissed the parallel state AG complaint with prejudice for that very reason. Contrasting the state and FTC cases, the judge noted that he isn't aware of any case to unwind a transaction that was allowed to proceed after such a long delay, other than the federal government, to which he explained, quote, the federal antitrust laws grant unique authority as sovereign law enforcer, end quote. Anyway, this is a major case to watch, and it could take several years to unfold, so let's make sure to schedule a follow-up episode for when it's all over. In the meantime, thank you again for having me on your show. I hope that your listeners find it interesting.
Thank you, Josh, for this very timely summary, and thank you, everybody, for joining us today. A reminder that the audio and Josh's write-up is available on the ABA website, which we will post in the link to the podcast notes. We hope to see you all for our next episode. Thank you again, and see you soon.
We hope you enjoyed this episode of Trust and Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.